Good evening, everyone, and thank you for joining me for day 3 of these special Black History Month lives. Today is going to be an important day. It's going to be an important hour for all of us. We are talking about estate planning and probate. So I have an expert probate real estate agent with me, and I have attorney Barlay, who's been on our channel before, talking about estates and wills. Because one of the things when we're talking about generational wealth, a lot of people have been throwing that out a lot. Generational wealth. I'm trying to build generational wealth. But the truth of the matter is, and this is not even in the Black community, your generational wealth, 70% is lost by the second generation. So that's like your children. And then by the third generation, say your grandchildren, 90% is lost. So it's one thing to say that you're doing that, but a lot of people don't have a will or a trust. That's kind of like the foundation of generational wealth. So we're really going to start talking about that in detail tonight. So go ahead, put your questions in the chat. I'm going to let them both introduce themselves. We'll start with Wanda.
Hello, everyone, and thank you for having me here today, Shahida. My name is Wanda Rochelle, and I am a realtor and probate specialist, as she mentioned, and I service Georgia, Florida, and Alabama. And again, I'm glad to be here.
Okay, great. Attorney Barlay.
Thank you, Shahida. Appreciate the invite. My name is Thua Barlay. I'm an estate planning attorney with Lueder, Larkin, and Hunter here in the Metro Atlanta area. Been doing estate planning for about 15 years now and enjoy it. So it's a good opportunity to meet clients sort of on the best side of things.
Okay. So awesome. We're going to start with just an opening question, but again, put your questions in the chat. I see a lot of people are signing on. Jojo says hi. Nico says hi as well. And then Rhonda Marie says, thank you for this. So thank you for joining us tonight. And if you're catching the replay, I want you to look at the timestamps. We're going to have all questions stamped by the time we put up the replay. So let's start with this question for Wanda. So with the majority of people not dying with wills or trusts, if you know that your parents don't have a will, don't have a trust, and they own a home, they have assets, and you think that's your inheritance, right? What should you be doing to try to protect that those assets? What can you do if they don't have a will or a trust?
I would say what we should do is meet with your parents, have a family meeting, and sit down and just talk about it. And sometimes that's not easy because the parent may want to brush it off or procrastinate, but kind of be adamant about it. Meet with your mom or dad and have a conversation as to what they want to do with their assets. Invite all family members if possible. And you also want to have them, I would say, go ahead at that family meeting, if they're willing to do it, go ahead and write it down and then set up a time where they can go and meet with an attorney to put those things in place. And also while you're doing that, it's important because I realize sometimes, Shahida, that even when they pass away, sometimes people forget some of I call them the little things. They don't have a key to their parents' home, especially if they live in another state, or they don't know who services their utilities. And then if that loved one passes away, they can't get in the house or don't know who the water company is. And so you want to just sit down and write out everything, have a family meeting, and then hopefully they will submit to it and meet with an attorney.
Okay. And let's add this to it, you guys, because we're a family. We're going to talk about it like family and be authentic as possible. Do it while they're in their right mind. You don't want to wait when your parents are too old, right? So you make these decisions. They may be starting to get dementia, that sort of thing. You want to make sure that you're doing it early. You don't want to wait till they're sick. You don't want to wait till that's when it's harder to have these conversations. But Wanda, I love that idea of having that family meeting, but make sure you're having it at the right time. Please have it at the right time. And Wanda, I have Wanda here because she sees when people are trying to sell their parents' house, when they're trying to do all of those things and all the problems that typically comes in. And she has a great YouTube channel with some of those issues that come up. So, and the question I have for you, Attorney Barlay, it's okay. A lot of people think that attorneys like yourself, you went to law school, you got all those degrees, and you might be too expensive for them. What do you feel like? What was your recommendation for people that think that the trust process or the will process just may be out of reach for them?
Great question, Sheeta. And as an attorney, I always highly recommend having an attorney. And I think one of the key things is there are various number of attorneys that do estate planning, that do wills and trusts. And so there will possibly be an attorney that meets with your budget, depending on what it is. So I think the best thing to do is always check around and see if there's somebody able to create the documentation for you. So that's really the first thing, is make sure it's done by an attorney. Now, there are some other options that you can have, like downloading forms or things of that nature. I caution you that when you do that, make sure you understand exactly what you're doing, because some of those fill in the box, they, in the grand scheme of things, they may be better than not doing anything at all. But sometimes the hardest part is not knowing what you don't know to ask. And so those forms won't tell you some of the things that an attorney who has experience, who's done it previously, will be able to guide you through. So yes, ideally use an attorney. If not, there are some forms that you can use, making sure you understand the process, so at least you don't have anything to leave behind. So,
okay, very good. So let's we got our first question. Hi, Pauline. We have our first question. This is for the attorney. Can a will be signed by a person diagnosed with any stage of dementia?
Great question. So there's, in order for somebody to sign a legal document, they have to have what's called capacity. They have to be able to understand what they're signing. Now, the capacity needed to do a will is slightly lower than maybe functioning on a daily basis. In general, you just have to know the importance of what you're signing. You have to know, in general, what you're distributing. So it's a little bit of a lower capacity than most people. So it really, at the end of the day, it depends on the stage of your diagnosis of the dementia. Most attorneys, I'm included, will have a checklist of things that we like to ask our clients, sort of to give them a sense of, hey, is this something that we can do? So I have initial consultations with clients, and really at the initial consultation stage is where I'm gathering information. I'm talking about loved ones, but I'm also analyzing the client to make sure that they're fully aware of what they can do. And then at the end of that consultation, I either tell them, yes, I can do this for you, or no, I just don't think you have the capacity. And also, most patients have physicians, they have doctors that you can possibly also communicate with and ask potentially, does your patient have the capacity to do a will? And so it's important to ask.
Very, very good advice. Good question, Pauline. So Rhonda Marie has a good question. I find that people do not understand a trust, and I have two special needs daughters. I've tried to find someone in Maryland. One attorney wanted to charge me $5,000 to start a monthly fee to maintain a trust. So let's talk about the difference between, I know this is a question you get asked a lot, the difference between a will and a trust. I'm gonna put it down because I'm covering up Wanda's face, but tell us the difference between a will and a trust.
I'll answer that question, and I'll also come back to that specific question, because it goes into more detail than I think maybe she might need sort of clarification. But in general, both a will and a trust are vehicles to transfer assets upon your death. So really think of them as similar types of vehicles. And I've explained this probably on my channel, but explain this in general to my clients, is the way you look at it is the same type of vehicle, same, let's say, make and model of car. So the will-based car, when you pass away, that car has to go into the shop, which in my analogy is the probate court. Has to go into the shop to get tires rotated, oil change, to get your executor appointed, and then it's ready to go on that journey. So the executor there then can execute your wishes. Whereas with the trust, when you pass away, because you've been doing oil changes and tire rotations throughout the life of the vehicle, it's automatically ready to go on the journey. So the driver just has to step into the driver's seat and it's ready to drive. So you can put the same amount of provisions in there for the most part, and the same amount of instructions. Now, there are benefits to the trust and things. There are factors that people look at as to why you would be preferably in a trust as opposed to a will. Things like if you have properties in different states, that's a big red flag. You probably want to be in a trust, because with a will, again, you have to do probate. And in case where you have properties in different states, you have to do a probate in those different states as well. Now, to answer, I think it was Rhonda Marie's question.
Yes.
So, yes, special needs trusts are a subset of estate planning. So, I, as a generalist, don't even do elder law or special needs because they're very specific. And unfortunately, yes, they do cost because there are several laws that have to be complied with. And so, setting up a special needs trust is much more intensive than let's say, a standard trust, which we call a revocable living trust. So I'm not necessarily surprised that it would cost that much to do it. But you just have to understand there are a lot of things. I think with special need trust, one of the things, and not to go into too many details, but one of the main things is there are governmental benefits that are being applied for the child. And if you create a trust that doesn't have specific provisions in it, then you would disqualify that child from receiving those governmental benefits. And so the special needs trust allows the child to receive the benefits and still maintain certain funds within the trust to sort of supplement those benefits. And so, again, with all of those moving parts, you can see why it would tend to be more expensive than your revocable living trust.
Okay. Very good. I'm going to put a slide. Let's see if we can go like this. I want to make sure we can see Wanda's face. All right. So, all right. Very good. People are thanking us for having this discussion. I appreciate that. Now, and one person said, I think it was Rhonda Marie again, it seems people of color are not as aware of all of this. I thank you again for this information. It's valuable. And thank you for joining us on this tonight. We appreciate you being here. And one of the things I was listening to a podcast or something, and they said, well, why don't more Black people have like will, especially Black people in America? Like Black people in America have to come through like slavery and descendants of that. Why don't they have, wills and trusts on the same level? And one person said, we've had so much trauma in our lives. A lot of times we don't want to think about dying. Like we're trying to get through the day. We're trying to go get on our jobs. There's so many things that are, we're up against in our life. We don't want to even think about death and plan for it. But the one thing, because when I was younger, I'm not going to get into a big story, but I was in a tragic car accident where a family member died and I was in the car at the time. And so one of the things I know that you're not planning on, we were going to the movies, right? And we got into this car accident, he died. And we didn't have that time to say, okay, let's plan for this and plan for that. So don't think that you're going to have that time all of the time to plan. And so that's why it was important for, especially once we had kids, to make sure that trust was in place, because you could be coming home from work and not make it home. You could have a heart attack, Don't think that you're always going to have that time to plan, because those things are tragic for a reason, because they happen unexpectedly. And I'm sure all of us can point to an instance in your family where, God forbid, somebody dies earlier than what you anticipated. It's not always going to be that. It's going to be an older grandmother. It could be your husband. It could be your mother dies unexpectedly. So you have to plan for this. So I try to think about it as it's just a checklist. Like a checklist. I got to get a will, got to get a trust. I'm not going to linger on the death and think about that, but I'm going to just check it off. It's done. And I don't have to think about it unless something in my life changes. I really don't have to think about it that much anymore. So think of it more as a checklist. Like as an adult, you need a will or a trust. You need life insurance. You check that off and you don't need to think about it that much anymore. Okay. So that's what I like. Let's answer this question really quickly. What is better, a will or a trust? And I'm going to let the attorney answer this, but I'm going to say why I chose a trust. It's because of the probate issue. What he was talking about, when you have a will, then your family members have to go to a probate court, even if you have a will, where the judge has to look at it and make sure that there's no issues with it. When you have a trust, it goes straight to the executor, whoever you said was going to be the executor, and then they implement your wishes. They don't have to go to a judge. They don't have to go to a probate court. Everything kind of just goes to that person and they can just handle business. So it's just avoiding that extra step of having, those things happen. And I'll let you both answer this, because I know you go with a lot of people that don't have a will and don't have a will at all. Wanda, what do you think is better, a will or a trust?
Definitely the trust if you have real estate, because like you said, you avoid the courts, because I've seen where some of my clients, they're waiting for, especially during COVID, they're waiting for the judge to answer. Or I had a call today and they filled out the paperwork and filled it out incorrectly. They paid $250 for the petition. It was not done correctly. So now they have to resubmit it. And guess what? They have to pay again. So I think we can afford it. We can afford Beyonce tickets and cruises and vacations. It just has to be a priority. So I think the trust is the better option.
Okay. And I would say one is more expensive. Like the trust option, at least when I did it, the trust was more expensive than the will. But I called an attorney. I didn't know attorney Barlay at the time, but I called an attorney where she was having an end of the year special.
Wow.
And we did our trust for $2,500. So I don't know what the prices are now, but we did our trust at the time for $2,500. So attorney Barlay, which is better, will or trust?
Yeah, I would have to agree. The trust is definitely better. Obviously, what I do is I try to do a document that benefits my clients the most. So again, as I mentioned, I have a checklist of things that I go through to determine whether a will or a trust is better. Now, because when I meet with a client, I do an initial consultation. From the initial consultation, I'm not saying you need a will or you need a trust. I'm sitting and listening. I need to understand what assets you have, and I need to understand your loved ones and maybe the complexity of your loved ones. As previous mentioned, perhaps I have special needs children. So those are things that you listen for and try to understand. But for the most part, I think a trust is much more better. And to go back in terms of answering the question about how as Black folks, we're not quite as sophisticated in understanding trust. And I think being in a trust helps you develop that whole mindset of it is in trust, that I'm holding it in trust for the next generation to potentially have it for the next generation thereafter. And so I think it's a good sense and good idea of that alone. If that were just the case, that's why I would prefer a trust over a will. But again, as I mentioned, avoiding probate. One probate is difficult enough, but imagine you have properties in different states. You've got additional probates. You've got minor children. All of these things sort of highlight the reason for a trust. And I guess one of the key differences between a will and a trust is that a trust becomes effective upon signing, whereas the will doesn't become effective until you pass away. And so, yes, as I mentioned, you can put the same provisions in both the will and the trust, but you can also put additional provisions, what I call disability provisions. What happens if I become disabled? You can put those in the trust because it's effective upon signing, whereas you can't put those in a will, again, because it's not. Now, and what I want people to understand is when we talk about will or trust, we're really talking about central documents, the central focus documents in each of those plans. So I always tell people that's why I call it a will-based plan or a trust-based plan, because there are additional documents that are sort of supplementing that will or trust, like your power of attorney, your advance directive for medical care, your HIPAA authorization. There are a whole bunch of other documents. And so get into the mindset of understanding that that's just the central document to handle most distributions, but there are times and places where we need the additional things to take care of our circumstances.
Okay, so Nico says, I'm confused already. And we don't want to confuse you. Correct. But we want you to say, okay, I think just to simplify it, what is your plan? When you die, what is the plan for your assets? And you can do that in a will, or you can do that in a trust. And then you may have to do a little consultation with a lawyer to say which one is best for you. We already know that the will is going to be less expensive. The trust is going to be more expensive. We know the will, your family will have to go to probate court, like go to a court with your will. We know a trust, they don't have to do that. So if you just kind of keep those things in your mind, and we'll give you some examples. I know in my trust, I'm giving you an example. I think you can't put this in a will, but in my trust, I have like who can pull the plug on me, okay? Like in the first position is my husband. In the second position is like my mother. In the third position is my sister. And I picked the sister that is gonna leave me on longer than the other sister. So I think those are some of the provisions you can put in a trust that you can't, because I'm still alive, right? What Attorney Barlay is saying, in a will, you have to be dead. And that's when the will comes in effect. The trust allows for a little bit more. You think through things a little bit more. My husband has another 3 people. He's not going to let my sisters pull the plug on him. So he has me. he has, his mom, he has his brother. So those are some of the things in a trust that you get to really be like real specific as to what happens if you're incapacitated and you can't make those decisions. But we're not going to try to confuse you. You might have to watch the replay. But we want you to get this. And I don't want you to say, I'm so confused, I do nothing. You want to just, keep at it, pay attention. We're going to try to give as many examples as possible. But I'm happy that you're here because this is the first step of knowing, especially, I don't know your age, but if you have parents that don't have a will or a trust, you have to at least start that conversation. But we're going to get through as many questions as possible. All right. So I had some other questions we talked about. That was a really good one. Let's talk about reverse mortgages. And I think Attorney Barlay can probably get this one first. Would you mind explaining reverse mortgages and how it affects the next owner when the home is passed to them? So they're going to get, I guess, regardless of a will or a trust, they had a reverse mortgage, it comes to them. What happens typically?
Great question. And probably one of the few questions that I may have to pass on, because one of the things I do real estate closings as well. And I have run into reverse mortgages, but I don't do them on a regular enough basis for me to be able to understand. What I can tell you is that the whole idea about a reverse mortgage is allows typically an elderly homeowner to pull some of the equity out of their property and not have to worry about the monthly payments. So they pull the equity out, and it's almost like an annuity where it pays them a certain amount based on the equity that they have in the house. So it doesn't, in my mind anyway, it doesn't really change things in terms of the acquiring. I could be corrected, but in terms of the acquiring of the property or the passing on of the property after the person passes away, you still have an outstanding mortgage that will still either need to be paid off or if it's sold, part of that process as well. But it really is the key there is to help primarily an elderly homeowner not have to worry about the burden of making monthly payments on a piece of property.
Okay, good question. All right, Wanda, do you have anything to add to that? Anything with reverse mortgages?
I don't have a lot of experience with them either. I remember being in real estate school. They said stay away from them. I do remember that.
Okay, but they will be paid off because they're going to put a lien on your parents' house. If it's your parents, there's going to be a lien on that house. So it's not like you guys can say, oh, she died and the debt went away with it. That lien is going to be on the house because they were paying that out. And one of the benefits to them was that they were going to be able to, benefit from that equity. So there will be a payment that the estate has to make to get that lien off the house. I'm pretty sure. Yeah. All right. So we're going to have both of their contact information and their websites. He is in Georgia, but he has a link to other attorneys as well if you need an attorney outside of this state. But very good question. In the description of this video, plus at the end of this, we'll have them give you how to reach them best. Okay. Thank you so much. All right. So what's the difference between a irrevocable and a revocable family trust?
So, and I assume that the question's for me, but a short answer to this question is primarily the difference between the two is the nature in which you can make changes after a trust is created. Irrevocable trust, and for the most part, you can't make changes after it's done. Revocable, you can make amendments and changes after that. So that's one distinction between the two. The second distinction is primarily the reason for creating them. In most cases, irrevocable trusts are used primarily to reduce the amount of estate tax that you may potentially pay. So it removes a particular property out of your overall estate. So you'll see that in what they call Medicaid trust. You'll see that in what they call irrevocable life insurance trust. It's really a mechanism to try and remove assets out of your estate to reduce the amount so you're not paying as many taxes. For the most part, I do more revocable family trusts or living trusts because, again, more than likely they're going to be making changes. I tell clients all the time, you're really, with estate planning, you're taking a picture in time. As much as we put provisions in there to address future circumstances, we know that things will change. And so we maintain relationships with our clients so that in 5-10 years, if there's birth, death, divorce, or marriage, anything of that nature where you need to amend your documents, that's when those things are important to do so.
Right, because if I get a divorce, my husband ain't gonna be number one on pulling that plug. I got to change that whole thing. So you have to think about things like that. I'm not getting divorced. He'll watch this playback and say, why you say we're getting divorced? I'm not saying that. All right. But those are the things you have to think about. Like he said, if there are any changes. All right. Nico says, I'm so glad we're having this discussion. Pauline says, we equate making a will with calling death on ourselves. We make a will, we're going to die the next day. Not going to happen. So just don't, like I said, do it as a checkbox. It's not like, oh, I bought life insurance. Now I'm about to die. I made a will. Now I'm about to die. What do you have to say about that, Wanda? The fear that people have.
Preparation is always best. I mean, all of us are going to leave here. So I feel like this, why put your family through that? I see the heartache and pain that you leave for your family when you don't have will or trust in place. So why do that? That's not fair to them.
Okay, good point. All right, Tina, can I add my investments? This is for attorney Barlay. Can I add my investments, retirement funds to a trust, or are they handled separately?
That's a great question, Tina. So in general, yes. So the whole idea of a trust, again, to avoid probate is because all of your assets are transferred into your trust, a process that we call funding, where you're actually placing assets into the trust, either by listing the trust as a beneficiary or making the trust as the owner of that particular asset. So that's the whole idea. Now, and what I do with clients, because we have a final meeting called a funding meeting, what I do with clients is we go asset by asset, because depending on the type of asset, you may not want to put it directly into the trust. So federal government passed a law about 2-3 years ago that was amended just last December, called the Secure Act. So whereby before the Secure Act, we were putting all what we call qualified investments, like your Roth IRA, regular IRA, we were listing those in the trust. But with some of those changes and how they treat the beneficiaries, we're now switching it to put your spouse, if you're married, as the primary instead of the trust as the primary. So there are changes. In short, to answer your question, in general, yes, we're transferring assets into the trust, but it depends on the particular asset. And that's why, again, going back to the first question about the need for an attorney, is you're hiring somebody based on their experience, their knowledge, and so they can guide you through that process of determining how each asset should come into your trust.
Okay. All right. And Wanda, while I'm getting the next question, tell me how most people find you as a probate expert. Who are your primary clients? When are they calling you?
They're calling me when their loved one has passed away and they need to sell their loved one's property.
Okay. And
Yes.
what happens if there's no will? Like, I know some people may have a will or a trust when they call you. I'm sure the vast majority don't. Mm-hmm. What has been the difference when somebody comes with you and there's a will in place, and when somebody comes to you and there's no will, no trust in place?
When there's a will in place, the judge has already given the letters of administration for me to list the property and sell it. If there is no will, then we're waiting. They're going to go and file the petition. There may be heirs that don't agree. There may be heirs that can't be located. There may be the house is abandoned if nobody lives there. The person may live in another state and they're trying to figure out how to empty the house, sell the items in the home. It's a lot of different.
Let's just say drama, okay? Let's just say drama. And Wanda has on her YouTube channel, she has buying, and your husband he died, but he had a mistress with a child. What happens then? You don't have a will for that. Siblings fighting over property because there's no will. Mama wanted me to have this. Mama wanted me to have this. This is my house. I've been paying the taxes on this house. Doesn't even matter. Attorney, let's talk about that. So, you've been paying the taxes on a property, still dies without a will. Does that make it your house because you've been taking care of it?
No, absolutely not. Unfortunately not. No. And I'm sure it depends also on how long you've been doing it. But no, in general, it doesn't make yours, because on title, it's listed as that particular owner. So At the minimum, you may get compensated or reimbursed for making those payments, but it does not give you ownership in there. And I think Wanda keyed in on another distinction between a will and a trust when she mentioned, so when you petition a will to the probate court, so let's say in the will you have the person that passed away had 2 children, he had 3 children, A, B, and C. In the will, he said his property should only go to A and B, right? By petitioning the court, you still have to send notice to A, B, and C, even though C isn't part of the will. Now, in a trust, if you had just said A and B, because it's a private document, you don't necessarily have to notify C. As long as C is not a beneficiary of the trust, it doesn't have to, he or she does not have to be notified. And so that's another distinction. And again, we're talking in sort of the kumbaya world where you submit a will, everything's accurate and correct, and the process is smooth. But 9 times out of 10, there's going to be delay. And so how do you cope with that delay and address it? And I think that's key.
Juan, the last question I'm gonna take for you, and I'm gonna take this next question. What if you got half siblings? How are they treated? Do they get half and I get full because I got the same mom and dad?
And I learned this from Attorney Barlay. A half sibling is a whole sibling.
Say it louder.
A half sibling is a whole sibling.
So don't think they're getting less because they don't have the same father as you. They don't have the same mother as you. They're getting the same amount, unless you made provisions in a will. The court sees them as half a sibling is a whole sibling. Anything else you want to add to that?
Yeah, at the end of the day, the court is looking at who is the child. So the person that passed away, their child. So if you have, let's say the father passed away and you have half siblings, step siblings, as long as they were the father's child, they inherit the father's property. So again, that's why I always go through that kumbaya world where same father, same mother, everybody gets along. And then of course the real world where there's blended families, stepchildren, half siblings, and you can see how some of that confusion can really be sort of embellished or enhanced.
All right, Classic Didi says, do you need a trust basically without owning property, or do you do a trust without owning property? That's for Attorney Barlay.
A great question. Now, short answer, you don't. It's a little bit sort of deceiving to think that owning property is the only reason for a trust. So I could be a millionaire and not own any property in my individual name. I still need a trust for that. So really you look at it from a holistic standpoint. At the end of the day, do you have assets? Do you have loved ones? And how do you determine that you're going to transfer those assets to your loved ones? Property is just one of the many assets. You have retirements, you have stocks and bonds, you have life insurance. There's so many other things. Now, what I would say is typically if you have property, you have those other assets. And so, yes, you would probably be more amenable to a trust. But again, I don't want it to be simply a sort of a focused conversation. Oh, I don't have property, so I'm not getting a trust. I don't think that. You have to look at it from a holistic standpoint of assets in general. I could have a Tiger Woods autographed picture that's worth $10,000, and I don't have a house, but I have a painting. That's still, again, need for a trust to be able to transfer that painting to your loved ones without any issue or upon your death. So it just depends.
Great answer. Please like and subscribe. Liking this video will help it get pushed out to more people that need this information. So take a moment while you're watching this and hit the like button, that thumbs up button. I appreciate it. All right, let's get back to these comments. All right, so let's see. I lost my spot. Let me see. Somebody said, according to the panel, trust are the best option. So yes. Nico says, I'm loving this panel. All right. Thank you.
Nico, from confusion to loving. So I guess we're doing great.
Yes, we're doing good. We're doing good. Okay, so this is a question. What is the amount you should start for a trust or a will? I guess they're asking, the value of your assets. I'm thinking, like, is it the more money you have that you should get a trust versus you have less money, you get a will? Like, is there any distinction, Attorney Barlay, they should make? Like, I guess if a trust is costing you $2,500 or $3,000 and all your assets worth $3,000, it may not be worth it.
Correct.
At what point is it worth it for you to consider a trust?
you have to do a cost benefit analysis. You know, hey, wills are trusts are typically more expensive than wills. So again, if you don't have the assets, then you probably be better off with a will or a trust. But again, I go back to what do you want to have accomplished? Because that's what I have with clients. When clients come to me, they don't necessarily say I want a will or I want a trust, or you're going to put me in a will and put me in a trust. I tell them, hey, give me more information. Tell me about your loved ones. Tell me about the number of children that you have. Are they minors? Are they adults? Have they gone to jail? Because I tell people all the time, you could have two sets of millionaires. One has 5 grown kids. One is, name it, good, and they're all adults and well, and they take care of things. And you could have the millionaire with the same amount of assets, but he's got 3 minor children. He's got a son that went to jail and a daughter that's addicted to drugs. Now, so that person is more likely, obviously, that they're going to, well, not obviously, but that they would be better off in a, I know I say obviously, and then people, so there would more likely be a trust as a good candidate. Now, it would be for both of them, but there's more considerations to have as it relates to individual things. So don't focus too much on assets necessarily, but what are we trying to resolve, the issues that we're trying to resolve.
All right. And then ask some questions. If you guys are in a probate situation now, Wanda or Attorney Barlay can help you with that, how those things get resolved. Wanda has, again, I posted her channel at the very top. Our moderator can post it again. Y'all have to watch her videos because she gives real life examples of people in that, in that situation at the time. So Tony has
one other thing before I answer. Okay. Now, and the question could also mean, because I've had clients, in fact, I have a client right now where we did a will-based plan for him in 2016, and he's come back and we're doing a trust now. He's acquired more property since then, but he's also, even some of the property, it's been the same from before. I think what has happened is he's experienced some things in between the few years that realized, okay, I should have been in a trust, because he has properties in Mississippi and Alabama. And those are, again, red flags as to why you would be in a trust. But it could be a transition because we're always just taking a picture in time. So it could be that right now you don't need but a trust and some additional documents. It could be 5-10 years from now when you family, properties, things of that nature, you transition into a trust. And so maintaining that relationship, like for instance with me, I gave him credit for the trust because I created his will. And so when I did his trust, I gave him credit for having done the will earlier. So I didn't just charge him like I would a regular trust. So it may be a phased up sort of approach for clients to have.
Okay, let's get this question. All right. So those of you that have siblings, if a home is being passed to siblings, but one sibling, that holdout sibling, right? The one is like, I'm not selling. Can we buy out their share? Any option? So they don't want to sell. Say there's 4 siblings, right? And one's like, I'm not selling. We need to keep mama's house. This is her house. We keep this land. They gentrifying the neighborhood. And we need to keep this property in the family. What are the other siblings' options at that point? I'll let Attorney Barlay take this question. And then I want Wanda, because you've been in this situation, how that typically goes down, I guess. Okay, go ahead, Attorney Barlay.
So it depends on where you are. So if you have this situation and you're in the court system, then I would say leave it to the court to sort of address some of those things. Because again, what will end up happening is an appraisal of the property is done. They determine, let's say there's 5 of you, they determine it's $100,000 for the property. If one doesn't want to sell, then you can buy the person, or that person who doesn't want to sell can buy the other 4 people out, or refinance maybe. But there's so many different circumstances that affect those things. But at the end of the day, there has to be some form of agreement that comes into play as to what happens. And maybe we go back and we say, what would mama have wanted, or dad, what would he have wanted in terms of this property? And again, this is the reason why a will and a trust is important, because you're taking a whole lot of this conversation, this discussion out of play, because you're putting into place what you prefer to have happen. And yes, you may not be here, but you're trying to avoid a lot of this sort of discussion and dissension that would happen after you pass away.
Okay, Wanda, do you have any examples of families and how this has happened in homes that you've had to list?
Absolutely. And I actually just did a video with Kevin, who you featured on your channel,
yes,
with the lender, and we talked about that. And so it is possible. I think what people miss though, Shahida, is that you have to qualify for it. So if your credit score, you like the mortgage company, they're still going to want the same criteria. You're going to have to still have that credit. You're going to have to still have the down payment. So it is definitely possible, and I've seen it happen. Yes.
Okay. So good point. So basically, if you're gonna have to buy what Attorney Barlay was saying, you may basically get a 20% discount, right? Because you don't have to buy yourself out, but you're gonna have to give each of your siblings typically $20,000 to get them out of your way. Because if you sell the house, they would have got 20,000, and you never know what everybody's not at the same economic level. Some people are like 20,000, not a big deal. Keep the house. Somebody's like, I need that 20,000 to pay my bills, send my daughter to college, do something. So you want to make those agreements ahead of time as much as possible. And like she said, if you don't have the 80,000 cash to pay them out, you got to get a mortgage. Can you qualify for a mortgage? If you already have a house, can you get a second house? All of those things you have to think about. And I would say if your parents don't have a will, start thinking about that now. You know the sibling that's not going to agree, right? So start thinking about that now. All right. Thank you. Thank you. Let's see. My partner and I have a house together. I'm going to go back to the full screen. Let me see. So nobody's blocked. My partner and I have a house together. There is no will. So can his adult daughter petition a court if he was to pass away for a portion of the house? And I know this varies by state, but let's talk a little bit about ownership. Like we call it tenants in common, right? Or tenants of rights of survivorship. So tenants in common means, if one person dies, you could give their asset, their portion of it to somebody else. Rights of survivorship is you die, the house is yours, right? The house is the other person. But I'll let the attorney take this one.
Yeah, and great response there, Shahida. Because Robert, I have, this is almost like a law school hypothetical. So I have several questions I would ask, because you say partner and I. So again, as Shahida mentioned, how are you two listed on the house? Because that's going to be key and important. Depending on how you're listed, depending on whether the will even comes into play. Because as Shahida says, if you're tenants in common, it doesn't. Then the will does come into play, because that portion will go into the will or the estate, and then there could be discussion on that. If you're joint tenants, then it would automatically come to the survivor. So even if you had a will, that would be an issue. My question is, what state do you live in? Next question is how is the deed titled? So the deed that you and the partner gained ownership of the property, how was it titled there? Because again, those are things that could potentially be an issue there. So, but I think that answers it. And again, it goes into make sure you address those things now, because what is a hypothetical now can be a real sort of issue upon death that we see going on in many different ways and scenarios.
All right, I'm going to talk on this really quick because I have an example. I was at a closing. I'm representing the buyers. Okay. Now this couple was buying it, and one of their parents. So you have a couple and they're buying like with their mom, right? And they're buying this house. And at the closing, the mom says, well, and she was older, she's the mom, she was older, and she had another son. So this is to say her daughter, and she had another son. So at the closing, she basically was saying, hey, if something happens to me, I want my portion of this house we're buying together to go to the son. And like the whole closing kind of like stopped, because they hadn't had that discussion ahead of time. So if you're buying with other family members, this needs to be a discussion that you guys have. If you're buying, it's like a second marriage. This is a discussion y'all have to have, because in your spouse's mind, they may want their portion of the house to go to their kids. They have no other assets. It's their only asset. They want to leave it to their kids. Or if you're buying with your parents, they want to leave it to the rest of their kids. They hadn't had that discussion ahead of time. So we're talking about how you're going to own it. I think they wind up owning it as rights of survivorship, because if the mom dies now, it goes to the couple. So the son would get nothing. And that's not, I don't know if they changed it after that, but those conversations were not had at the very beginning. So that does happen like in real life. So good question. Let's see. And I'm going to go back up, and Miss Amin Ra has posted, she put Rwanda's YouTube channel. So please check that out. What advice can you give if my mother hasn't done a trust or a will yet, has a home pre-marriage and a business after marriage, and we got lots of stuff going on. I think you need to look. and 2 stepchildren, and are involved in 3 biological adult children. So we already learned that a half child is a whole child, right? So we have to get that in our minds. But what would you suggest? So basically it's a daughter, the mother doesn't have a trust or a will, is married again. That's what it sounds like. I guess she's trying to protect her inheritance either way. What advice would you give for Attorney Barlay? Let me go.
Make sure you do some planning. It depends on it also depends on the state that you live in, Victoria, because certain states are what's called community property states. Other states are what's called separate property states. So if you live in a community property state, and most of this you can Google and figure out which state you live in. But if you live in a community property state, you have, even if it's a property that you acquired before marriage, as soon as you get married, that property now becomes community property. Obviously, there's some distinctions there. So that's key and important. But also, even if you live in a separate property state, there could be an equitable argument made by your spouse that, yeah, she may have bought that property before she married me, but after she married, I was the one taking care of the bills and I paid the mortgage on that property and I did X, Y, and Z. And so there's a whole lot of sort of back and forth that could be avoided if we simply, again, get planning in place that says my property, I want it to go here and there. And it makes it easier. Even if you need to get the spouse to sign off on those type of things, get them to sign off, again, to avoid any discussion or dissension after the fact. Because again, these hypotheticals become real when we see it on a daily basis. Juana and I, run into it at all times. So make sure those discussions are happening now. One of the things I didn't mention, I'm an estate planning attorney. I've been an estate planning attorney for 15 years. My father passed away almost 6 years now and didn't have a will. Again, so it's not an easy conversation to have, even with parents. Your son is an estate planning attorney, and I couldn't even convince them of that fact. So again, it's definitely not an easy conversation. One of the things I would add is be an example. If you're trying to get your parents to do planning, maybe you should do planning first and show them as an example. Hey, I've got these things taken care of and prepared, and so why don't you look at it and do? And then the other thing is just examples. You'll see it. People will pass around you with the things, with not having done planning, and you'll see it. Some of my best clients had to be executors. They had to be trustees. And so they realized the amount of work that it takes having to handle those. So even with a plan, it's about organization. So that when you leave this place and you know where all your assets are, but when you leave, you need to be organized enough so that if somebody steps in, they know which account you have, which policy you have, and where to find all of that.
Okay, and I love it. That's why I love my guests, because we're authentic, transparent. He said his own father, he's an attorney, 15 years. His own father didn't want to talk about it. We have these things in our community that we have to get over. And I love that example of you do it first. Don't be telling your parents you need a will, you need a trust, and you don't even have one. Because at least you can, tell them, hey, I went here, this is what I did, this is who I used, all of that kind of thing. So make sure you are being, like he said, an example for your family, for your community, and you do it yourself so you can, they can see it, because a lot of people can't see it. All right, Rena's looking out. There are over 100 people on here and only 30 likes. Let's get it. Let's hit that like button. All right, good question, everybody. Randy says, I always like afterwards. Give me that like. Let's get that like now. Okay. All right. Nico says, I was going to take a nap. I'm glad I didn't. And I turned on the television because I would have missed a great live. Thank you, guys. I'm going to try to get to so many questions as possible. All right, let's get to that question. BM, post your question again. He said, I couldn't get your question answered. Post it again. My grandmother, going back to this. All right, nope, not going to that one. Sorry. My grandmother had land in Louisiana. And again, because we don't know the exact laws of every state, we're going to give you a general answer, but hopefully this will help you. But when he died, his family sold the land because they were paying taxes on it. But my mom was supposed to get the land. How can my mom get it back? Like, what would be her first step in this instance?
Yeah, so I'll say it's very difficult to get the property back. She may get compensated for for her ownership. So if she was supposed to get the whole property, she may get compensated back for that. Again, there are so many moving parts with the question. I really can't answer. I tell people all the time, especially these formats, it's really not to answer specific questions like that, because I try to shy away from giving legal advice. And I don't do litigation, but and it is based on Louisiana law. But it's very difficult to see a situation where, and again, you put yourself in the place of the person who bought the property. They are a buyer. They don't understand. They didn't know any of this. They went to a closing and were issued this with marketable title. So they paid good money and they got it. It's hard for me to see a judge come by after the fact and try to reverse that transaction. Now they may say, hey, you who sold it, you need to compensate the rightful owner for it. But it's difficult to say that you would get the land back. But again, just go step by step, figure out, look at the title, see how because they would have had to have authority to sell it, first of all. And so look back at whether the authority was a valid authority or whether they maybe forged some signatures, things of that nature. But at the end of the day, I think what I can safely say is your mom will probably be compensated if, again, everything was done wrong. She could be compensated for the value of the land. And very rarely do I think that they'll force her or force the buyer to give the land to her.
Okay, and this is another reason, let me put this out here, why we get title insurance, because you never know the house you're buying, what didn't get done correctly on the back end. So get that title insurance at closing. All right, people are putting in Wanda's YouTube channel. Make sure you check it out. Great videos on there and very specific videos.
I want to
what can happen.
Say something.
Sorry.
Since I'm learning probate, I realized that let's talk about how there's property left and no one ever claims it, and it goes to the state. And I'm just alarmed at the amount of assets that nobody ever claimed because there was no will, there were no heirs. Nobody knew that Kim Smith passed away and left her house, and nobody ever claimed it. So now the government owns it. That's crazy to me.
Yeah, very good point. Tell them about the client you had where their teacher left in their house.
Yeah, I had a currently a teacher. I'm getting ready to list the house, and my client is probably in his 50s. His middle school teacher left him her house with some other heirs and left him as the executor. And so I'm in the process of listing the home, but his middle school teacher, they kept in touch all these years. And so even as we talk about a will, you don't necessarily have to leave it to your siblings or your cousins or whoever. You can leave it to whoever you want. And I find sometimes people want the executor to just be, it doesn't necessarily need to be the children. It needs to be someone that's responsible. And so his middle school teacher thought that he was the most responsible person to handle her estate. And I thought that was amazing.
Okay, good. Remember these stories. Nico said her mind is blown. So if my husband passes, he can leave half of his house to someone else. It depends on how you guys own it, right, Attorney Barlay?
Yes, it does. And yes, if you own it as tenants in common and he has a will saying it goes to somebody else, yes, it can happen. Now, again, it depends on where you live, Nico. If you live, fortunately, in Georgia, there's another thing called what we call year support, where you can get the property even outside of what your husband may dictate in his will. But again, every state is real different. But yeah, that is unfortunately something that could happen.
All right, thank you. I'm happy you didn't take that nap. Somebody said, this is so good. I was once an executor and learned about the drama. Let's talk about drama, right? And trust is the best way to go. So let's see. All right, let's see. Rhonda Marie has a good question. What are some direct questions? Let's give her like 2 because we have a lot of people on the live and we hit up against 7 o'clock. What are some direct questions we should ask an estate attorney to ensure we're on the correct track?
I'm not sure. I would, my general response would be, make sure that you're clear about the process, either the process with that attorney in terms of the documentation that he or she will provide to you, or just make sure you have a general understanding of estate planning in general. And wherever there's sort of a confusion, ask the question, because sometimes, like I've been doing this for 15 years, and so sometimes I may have a tendency to assume that you know what I may be talking about. If I say advance directive, if I say power of attorney, you may understand it. And I want my clients to feel free to ask. Again, for me, there's no dumb question. I'd rather you ask the question now than having to deal with an executor or beneficiaries after the fact asking that same question. And one of the great things that I like with the documentation that I provide is that it doesn't have a lot of what I call legalese. In fact, at the end of most of the wills and trusts, there's a definition section that will break down, what is per stirpes, what are some of the legal terms that you may see, and it'll give you define it within the document to further help clients. But in general, you're just trying to be comfortable with that attorney, comfortable in that they understand and know what they're doing, and that they are properly explaining it to you, so that at the end of the day, you can convey that information to your executor or to your loved ones from that standpoint.
And it's kind of like, since we're on this Black History Live, you want to make sure that somebody kind of understands. I know I go to a Black female doctor because she may understand some of the things that I may face as a Black female, right? So you want to make sure somebody, doesn't have to be a Black attorney, but it could be somebody that understands some of the things that you may be going through and understand some of the cultural things that we have as African Americans, as Black Americans. Cameron says, for some reason, Black people think talking about death will shorten their lives. And that's true. That's one of the things that we have a unique history, you guys. So some of the things that you don't even think about have been passed down to you, that we're not talking about death and we're not doing this, we're not doing that. We don't know where it comes from, but it comes from our history, right? So yeah, we have to just be mindful of that and face it, because number one, we're at the end of like the wealth, as far as wealth in America, we're very low in wealth, right? So the few assets that we do have, we need to make sure we protect it for that next generation. Is very, very important. All right, let me try to get through as many as possible. DB says, I think it'll be sickening if my property goes to the state when I pass away. Need to figure out everything, but I don't trust people much. Go ahead.
And Wanda brought this point up about it going to the state. So the state, excuse me. So in Georgia, if you just search for state-owned property, there's a website. It's under Georgia Department of Revenue. There's a website where you can go put your name in, and it'll give you any unclaimed properties that you may have. So I do that every once in a while, just in case there's something out there that, maybe my middle school teacher left me or something like that. Just hopeful, but you can actually search, depending on your state, you can search for unclaimed property, and it'll show up in whatever.
All right, so that's the gym for the night. Let's look for unclaimed property for your state. You could Google it, put the information in, and see if you. I've been on that site as well, just making sure. You look in your state and make sure, because there are businesses that people look at those and they try to find the person and they try to get a percentage, but you can look for it yourself. So just make sure you're doing that. All right, let's see. I found BM's question. He said, what is better? I'm going to go back to this. What is better if my child is underage, if something happens to me and I want to make sure money is spent on only her and assets go to her, but only her? Can I state that specifically in the document? So basically her child is underage, but she may not be like old enough to get the money, right? So what do you do in the meantime until they're old enough?
Great question, BM. Again, as I mentioned, you can put the same amount of provisions in a will that you can with a trust. And that's a question that I have with clients. They normally fill out a form before we meet. That form asks information about loved ones. So if I see a child that's under the age of 18, we start the conversation with what do you want to have happen if you happen to pass away before your child gets old enough. But we also ask the additional question, because 18 is what the law says that people are considered adults. In our minds and in clients' minds, it could be a lot higher than that. I have two sons. I'm not quite sure. I would say, and one's 20, one's 15. I'm not quite sure. I would say 18 is their age. I may say 25. And so really you have the opportunity to dictate that. And we have these conversations about what's important to you. What do you want to see happen with your child? Is education important for you? Do you want to see them go to college or high school or technical degree or anything? Those are the ways that you can put your wishes in documents so that whoever you leave behind, the trustee for your child's trust, again, could be within a will or it could be within a trust itself. That trustee has guidelines as to how to manage it. And I think that's important there when you're dealing with minor or any children, period.
Okay, I'm going to take this question. We're not life insurance professionals with an estate, but your life insurance will go into your trust for the most part, right? So if you're doing a trust, that life insurance, will go into that trust. I have a term policy, and the way that I see it is term is, I have a 20-year term. It's for the people that are dependent on my husband and I's money, so my children. So I did a 20-year term policy. So if they, that basically gets them out of the house, right? Y'all need to have your own jobs, your own things after that. That's why I did a 20-year term. And it was much less expensive, right, for me to do a term policy than a whole life policy. A whole life policy puts investments. It's not just life insurance. There's like an investment portion of that. So I would say at the minimum, until you kind of understand what you're getting with whole life, term is going to be very affordable for you. So maybe start there, and I'll let everybody kind of put their opinion of it. Again, we're not really professionals, but you definitely need some kind of life insurance. If people are depending on you financially, then you need some kind of life insurance in place. GoFundMe is not life insurance. Okay. It's not. That's what we're using now because we don't have enough money to bury our children or bury our parents or, handle business basically. So at the minimum, get your work policy, get a separate policy. Make sure you have some insurance in place, life insurance, and make sure, they made a law now. It used to be, I think back in the day, you get life insurance on anybody, but now they have to know that you're getting life insurance on them. So if you have like siblings, they're not living like the healthiest lifestyle and you may have to, pay for their burial. They don't have any money, that sort of thing. Then you may want to get, life insurance on them. You may want to, talk to your children's parents about getting life insurance on them because you're dependent on that child support. You're depending on those things to live. So those are the discussions you should probably have. Wanda, do you want to add anything to that?
Not really. I agree with everything you said. Just make sure that we have life insurance. Yes.
Attorney Barlay.
Sometimes our adult children don't know the importance of the 18-year-olds, 19-year-olds. We have to educate them on the importance of getting life insurance because they think they're gonna live forever.
I mean, like I said, tragedy does happen sometimes. Tragedy does happen. Attorney Barlay, anything you want to say about life insurance?
Yeah, I mean, with life insurance, I think the key thing is just making sure you have educated discussions with professionals because the professional will tell you the difference between term and whole policy. Yes, term may be cheaper, but maybe whole policy gives you better return for your buck. So it depends on what you need it for, and then they'll work in some of the numbers to determine what best fits for you. There's even policies that are sort of hybrids of it. Like you can get a term policy with what they call a return on premium. That means at the end of the 20 years, if you've been paying everything and haven't died, you get a portion or you get all of your premiums back. So there are variations to either those. So it's not just a term or a whole. It's different types of things. And you could get both. You could get a smaller whole policy, a larger term policy. So that's more of an in-depth conversation and what they need to look at you as a whole and see what you need it for, and they'll determine that. I tell clients all the time, because I get phone calls all the time of people telling me, well, is a trust good for me or is a will good for me? And I always have to tell them, I can't tell you, and typically I'm on the phone, but let's say we're on live. Tell me what color pants I'm wearing now. You would assume I may have a gray to match my suit, but you don't really know because you don't know me and we haven't had enough conversations. And I think that's how even this conversation with trusts, wills, and with life insurance is until we know more about you, we can't determine which is the best sort of product for you. So, and by the way, yes, I do have gray pants to match. That's by luck more so than planning. So
yeah, and life insurance is one of those checklist items as well. Check you got life insurance. Check you have a will or a trust. Those things that you need to do. Buy a house. Like we have to check off these things in our lives. Buy a house.
Because you have all this debt. So people don't understand or realize that if you put in a will that I want the house to go to my sister Sam. Understand that when that house goes to Sam, it's going to come along with the mortgage. So if you don't have something to either pay off that mortgage, like life insurance, or Sam doesn't have the necessary funds to take care of that mortgage, you're just really giving her additional debt more so than anything else. So that's why, again, I keep mentioning holistic approach. That's why we're talking about doing, that whole sort of research as to how everything fits in to make sure at the end of the day that your loved ones are taken care of.
And then make sure you're insurable, because once you get sick, I know diabetes is big, right, in the Black community. High blood pressure is big in the Black community. Do everything while you're well. Do your will, do your trust, do everything while you're well, because when you're getting these larger life insurance policies, you don't have to do health examinations for those work policies and that sort of thing. But when we had to do like a larger policy outside of work, they come with like a scale. They come to your house. They come with a scale. They're going to weigh you. They're going to see what your height is. They're going to take blood to see, like, are you already sick? They're not insuring you like, I'm going to go ahead and get insurance now that I got diabetes. I'm going to go ahead and get insurance now that I got diagnosed with something. It's going to be too late, or it's going to be very, very expensive and you can't afford it. So do it while you're young and do it while you're healthy. Of course, we're not planning on getting sick, but, don't think you're going to get it after you're sick. You won't be able to afford it, or they may not insure you at all. I want to say a couple of things. I have my first time home buyer guide. You're getting $10 because, y'all are, if you're on this estate planning is not sexy. It's not fun. We're not talking about lending and buying a house with no money and all that kind of stuff. We're talking about some real stuff. So if you want to buy my first time home buyer guide, you're going to get $10 off just for people on this live, right? It's going to expire within 24 hours. $10 off if you use the promo code ESTATE. Use the promo code ESTATE. I think I want to end with this last question. Please like and subscribe. I've said that already a couple of times. Please check out Wanda's channel. I think we put that in the link. You're going to have all of Attorney Barlay's information. So if you're not in Georgia, I know a lot of you are not, he can give you a link to a referral so you can find another attorney. So please add that. Okay, I wanted to get this. I saw the question. I'm looking for it one more time. Wanda, what would you like to say just to everybody, kind of just to sum it up? What's your best advice as far as probate? And, your parents didn't die. They died. They didn't have a will. What's your best advice for them?
Have the conversation and have it quickly. This is February the 9th. Put it on your calendar to have that family meeting before February the 28th. Don't procrastinate.
Don't procrastinate. Do it for Valentine's Day. Like, I love you. I love you. Let's talk about this will. They're like, why? You trying to kill me? Okay. Attorney Barlay. Well, I'm looking for this last question. Go ahead. Go ahead and say, like, what's your best advice for the viewers tonight?
Yeah, I agree. The best advice is plan. Start planning. Even if you're not sure exactly what the process is and what to do, seek out competent advice and start the process. I think what Shahida was talking about, life insurance. Yes, the younger you are, the cheaper it is, but also the younger you are, the more competent and able you are. So I have a lot of clients say, well, I'm only 30. Why should I be worrying about all of that? It's because this is the best time to be doing all of those things. So as you progress, you are just amending instead of starting to start from scratch. So again, as Wanda mentioned, Shahida mentioned, just plan, just start doing what you can at what you can afford at this point, and that you would be better off as a result.
Okay. So again, please like and subscribe. This is my last question. I thought this was a really good one. If you have other questions, just put it in the comments and we'll try to get to those maybe later, but go ahead and, after this video post. What if your spouse is someone that is not proactive? Okay. We always sometimes our spouse, not always on the same page, right? Is it possible to get a trust without the other? So we're one spouse, I want to get this trust, but the other one not even showing up. To have things in place for our children. So she wants to get basically a trust without them. Like, I'm not waiting on you. I'm getting this trust in place, or will. Is that possible?
Great question. Great question. So yes, you can do planning individually. Ideally, you want to do planning jointly. So really, at the end of the day, some of the questions I ask is, are assets held jointly or are assets held individually? If they're held individually without your spouse, then yes, you can do planning without your spouse. If they're held jointly, then you have to somewhat convince the spouse. It's similar to trying to convince your parents. You have to convince your spouse of the importance. And again, at the end of the day, it's how you convince. Tug on heartstrings. Hey, what happens if you pass away and I'm here with kids? When they start seeing that picture, it sort of helps them be more sort of proactive in terms of getting it done. But yeah, you're right. And with trust, one of the things, the differences also is with trust, you can have an individual trust and you can have a joint trust. With wills, you can only have individual wills. There's no such thing as a joint will, at least not in Georgia. So because you can have individual trust and joint trust, you can do planning somewhat differently if necessary. But ideally, with couples, I'd like to see them do joint planning because it helps the overall planning and the future of the family.
What Johnny Gill said, put on that red dress, put on those high heels. You're going to get a trust tonight. Get you a trust on Valentine's Day.
Use that.
Do what you got to do, girl. All right. Thank you, guys. Please like and subscribe. Thank you, Attorney Barlay. Thank you, Wanda. I really appreciate it. This is great information. I hope everyone enjoyed it. You guys have a great night.
Bye-bye.
Bye.